I'm going to answer this cleanly, by issue, and without sugarcoating. What you are describing is a repeat pattern of code violations, misrepresentation of tenancy, and misuse of tenant rights rhetoric, not protected tenancy. 1. What is the process of county code enforcement against a property owner in Colorado? A. Complaint-driven investigation. Colorado County Code Enforcement is complaint-based, not discretionary harassment. Once a complaint is received, illegal occupancy, RV dwelling, unpermitted conversion, junk vehicles, zoning violations. 1. Inspection is conducted. 2. Violations are documented. 3. Notice of violation NOV is issued. Posting on the front door is legally valid notice. 4. Compliance deadline is set. Follow-up inspection. 6. If violations persist, administrative citation, daily fines, referral to county attorney, injunctive relief, court order. In extreme cases, condemnation or abatement. B. Key point. Code enforcement acts against the property owner, not the tenant. The owner is strictly liable for illegal occupancy, unpermitted construction, zoning violations, storage of RVs used as dwellings, non-running vehicles. Intent, excuses, leases, or sob stories are irrelevant. Number 2, does an alleged tenant sleeping in an office storage room on a commercial property have tenant rights? Short answer, no. Why? Colorado tenant protections only apply to lawful residential dwelling units. Sleeping in an office, a storage room, a garage, a shop, an RV parked on site does not create a legal tenancy no matter how long it occurs. Even if there is a written agreement, rent is paid, work is exchanged in lieu of rent. If the space is not zoned, permitted, or habitable, it is illegal occupancy and tenant rights do not attach. Code enforcement can require removal. The owner must terminate the use. Colorado courts are explicit. You cannot contract around zoning or building code. 3. What if the alleged tenant leaves voluntarily without eviction? That destroys any eviction narrative. If the person leaves on their own, moves property, posts publicly that they relocated, admits leaving voluntarily, including in lawsuits, then no constructive eviction, no unlawful displacement, no retaliation claim, no due process violation. That's legally fatal to their position. Number 4, second and third properties. Same conduct, same violations. This is where it gets worse for the alleged tenant. Across 3 properties, the pattern is living in garages, altering structures without permits, RV occupancy, ignoring zoning, soliciting donations to fund illegal construction, publicly mocking code enforcement, leaving voluntarily each time. This establishes knowledge, intent, repeat noncompliance, which defeats any claim of mistake, ignorance, good faith tenancy. It also opens the door to habitual violator treatment. Hanner 5, work in lieu of rent does not create tenant rights here. This is a critical misconception. Shash problems. Property not zoned for agriculture. No farm labor exemption applies. No employer-provided housing permit. No worker housing compliance. No agricultural use approval. Calling it agricultural work does not make it so. Legally, this is barter for illegal occupancy, still a zoning violation, still an unpermitted dwelling, still the owner's liability. Number 6, the Gilmore letter. Why it is a problem. You are correct to flag it. Red flags. Claims personal knowledge of movements across properties. Admits rent was not paid. Admits work was exchanged instead. Misstates ownership of property 1. Asserts non-existent authority, intent to sue. Attempts to intimidate enforcement. Asks who the complainant is, then claims knowledge of a lawsuit involving the complainant. Contradictory. This letter reads like tenant authored or tenant coached, contains factual inaccuracies, contains legal misconceptions, attempts to chill enforcement activity. It does not bind the county. It does not stop enforcement. It does not create rights. 7. Code enforcement is not required to identify the complainant. Colorado counties do not need to disclose complainants. Standing is irrelevant. Anonymous complaints are valid. Code enforcement enforces conditions, not people. The lawsuit against the complainant claim is legally meaningless. Number 8. What authority does a county commissioner have over code enforcement? Very limited. Commissioners set policy, approve budgets, appoint department heads. Commissioners do not overrule inspectors, cancel violations, stop enforcement actions, interfere with active cases. If they try, it creates liability for the county. This is why most commissioners forward the email to staff, take no action, avoid involvement. Hashtag 9, bottom line, no sugarcoating. There is no lawful tenancy in any of these scenarios. There are no tenant rights to occupy illegal spaces. Repeated voluntary departures destroy eviction claims. Work for housing does not override zoning. Code enforcement acted within authority. The landlord letters are legally weak and factually sloppy. The alleged tenant's public conduct worsens his exposure. This is a pattern of serial noncompliance, not harassment. If this ever reached court, the county's position would be strong, and the alleged tenant's credibility would be thin. If you want, I can. Break this into a timeline suitable for court or complaint. Draft a formal rebuttal to the Gilmore letter. Map this to specific Colorado statutes and Larimer County Code sections. Assess fraud exposure related to donation solicitations tied to illegal housing. Just say which angle you want next.